Hi, this is Carrie with Carrie Concealed and the Active Self Protection Extra channel. And today we're going to talk about the right to remain silent and the ability to remain silent.
Hey Aspers, would you join me today in welcoming the newest sponsor of Active Self Protection, Mr. Target. Mr. Target is the sponsor of today's video. If you're looking for excellently engineered steel targets that will withstand thousands and thousands of pistol, rifle, or shotgun rounds, Mr. Target is my go-to resource. They've got self-sealing rubber targets too, and you can see us use them all the time on the Active Self Protection Extra YouTube channel. Hit the link in the description to check Mr. Target out and be sure to thank them for sponsoring today's video.
Well, the other day I was listening to the Ask podcast, and if you don't do that, you're missing out. There's some amazing stuff there. If you don't do that, I strongly encourage you to do it, and maybe even start with some. I'll give you a couple names. You could search and look up people that Mr. Mike has interviewed. Fred, Zach, Raul, and Dan. Those would all be great ones to start with. If you don't watch any of them would be great. Those are some of my particular favorites, among others. And if you do listen to the podcast and those names don't ring a bell, I bet they will after you think about them for a little bit. So anyway, when I was listening to the podcast, I was listening to one, I won't say which one it was, but I was listening to one where the gentleman who was being interviewed, we'll call him the defender, where the defender was explaining to Mr. Mike that he was an informed protector. He didn't describe himself as that, but I'm describing him as that because he was familiar with the works of Colonel Cooper and others. And he mentioned that he had made the decision years ago, maybe even decades ago, to, if he was ever, God forbid, involved in a use of force encounter, that he would tell police if they were questioning him that, so he said that he'd already made up his mind to say, I'd be more than happy to cooperate with you after I've spoke to counsel. And that was his plan. And then he was put in a horrible situation and had to use force to protect his life. And he mentioned that he was telling Mr. Mike on the podcast that about 30 minutes after first responders arrived, so this is within an hour of this critical incident happening at his house, that the lead detective came, and the lead detective sat down across from the defender and said, do you want to tell me what happened? And the defender explained that the detective explained, if you tell us what happened, then we'll have both sides of the story. But if you don't tell us what happened, we'll only have one side of the story. We'll have the other side of the story and not your side of the story. Excuse me. Sorry, I'm battling a little bit of a cold here, so I have a cough drop on my mouth, and I hope it's not distracting. And the defender explained that even though he'd made up his mind that he was going to ask to speak with an attorney prior to giving a long statement or explaining everything that had happened, that he and the detective just had a connection. And the defender explained, he said, I basically told him what happened. And the defender went on to explain, it worked out for me. He said, I don't know that everyone should do it, but for me, it worked out. He said, I was prepared to say, I want to speak with my attorney before giving a long statement. And yet that isn't what he did. And I'm so thankful that it did work out for this defender. I'm so thankful. And he wasn't charged criminally, and hopefully there won't be any civil charges or civil suits filed either. And what struck me about this is that many of the cases that I've had and many of the cases that my colleagues have had doing expert witness work, some of them are cases I haven't even actually accepted, but I've been called about them to consult on them, but I haven't actually taken them as cases. But I get to see all case discovery for the cases that I do take. And a lot of my colleagues require full discovery as well. I won't take a case unless I get full discovery. But if I got a dime for every time I heard a defender say to the detective that's asking them questions, I know I'm not supposed to talk to you, or I know I shouldn't talk to you, or I know it's best if I talk to my attorney first. And then there's a but that comes after it. And it can be something like, but you seem really nice. they're saying this to the detective, but you seem to understand why I did what I did. Or even, but you seem to be on my side. So I'm okay giving you a statement and answering all of your questions. In one case I had, it was even the defender said, it was a younger gentleman, and he said to the detective, who was a big, strong, burly guy, the defender said, um, I know I shouldn't talk to you. I read some books about that and magazines about it, but I'm a little bit intimidated by you, and I'm afraid what will happen if I don't answer your questions. And the detective went on asking questions, and the gentleman answered them. And sometimes I'm talking 3, 4, 5, 6, 7 hours worth of asking and answering questions. And so, why does this happen? Why, when someone is knowledgeable, that it might not be in their best interest to give a long statement after a critical incident, or they've made the decision that they're not going to say anything until they've had a chance to talk to the attorney? And I don't mean say nothing. These people are calling 911. They're saying, they're not necessarily saying, like one of the FLP attorneys years ago would say, don't say I shot that guy. Say if you call in when there's a shooting, and I'm not telling you what to say. There's no prescription or script that you should or shouldn't say. These are all decisions that we all have to make on our own. We just want to make sure that we're making informed decisions. So why is it that knowledgeable people, or people that are a little bit familiar with the aftermath of what it might be like in a use of force encounter, why is it that they change what they're going to do or do something different? Well, Dave Spalding answered that question for me. He's a trainer, career police officer. He's now retired from training, is my understanding. I think he teaches a couple classes a year now, but not very often. And he said years ago when I took a class from him, he said, we have the right to remain silent, but we don't always have the ability. Most of us don't have the ability to remain silent. And that made a lot of sense to me. So we're going to talk about this topic. This is going to be a 2-part series. This is the first of a 2-part series. And again, this is not telling anyone what to do. There's nothing in particular. There's not a script that you should be prepared to say. That's not going to serve you or benefit you. These are just giving us ideas to ponder. So we all need to make our aftermath plan, or have an aftermath plan. God forbid, hopefully none of us will ever have to use force to protect ourselves or those we love. But hopefully your aftermath plan will involve firearm legal protection. Here at ASP, our aftermath plan for each one of us does involve FLP. So there's nothing about this topic. Also, I want to make this really clear. There's nothing about this topic that I'm saying that is anti-law enforcement. Nothing. I am pro-law enforcement, and I'm pro you, or I'm pro my students, or I'm pro other responsible folks that just want to learn how to protect themselves and those they love. So this is not anti-law enforcement. I am pro my learners. So the very first thing I think it's important for me to understand is that I'm a human. Surprise, surprise there, huh? I'm a human, and I learned early on, I think 2014 or 2013, I took Mag 40 for the first time. And that's with Massad Ayoob. And if you have not taken Mag 40, I strongly encourage you to do that as soon as you can. If you can't do Mag 40, then Mag 20, that'll at least give you the legal aspects of it, and it's 20 hours of classroom time. But he travels a lot, and you can find him, and it's well worth it to take that course. There's just super important stuff in there that you can learn. So my Mag 40 course, the first one, and then in the Judicious Use of Deadly Force Instructor course, Mr. Moss talks about logorrhea. It sounds like diarrhea, but logorrhea is the compulsive need to speak, or some people call it diarrhea of the mouth. The problem is, after a critical incident, we have, most likely we've had this huge, all these hormones surging through us as we're trying to protect ourselves, or, those we love under the consequences of life and death. And if we start talking before our brain is engaged, that's not great, right? That can cause problems for us on down the road. As humans, we often feel the compulsive and consuming need to defend ourselves and our actions. So we want to explain why we did what we did, and we want people to understand that, and to at least have an understanding of it. Also, most humans have a deeply ingrained subconscious and desperate need to satisfy the questioner. So, whoever it is that's asking us questions, we have this desire to answer their questions, to help them. And that's just a deeply ingrained, it's a subconscious thing that a lot of us feel the need, a desperate need to do. So, and another reason why we may talk excessively after a critical incident is because talking or yelling or crying or laughing, um, talking really is one of the quickest ways that you can get rid of that excess buildup of adrenaline and come back to more of a normal state again. And that's a state that our body wants to be in, is a normal state, not in an amped up state. So, understanding that those things happen to us as humans, I hope helps us realize the importance of having a plan for what we're going to do and what we're going to say if, God forbid, we do have to use force to protect ourselves. So, in my experience, attorneys are typically the ones that speak minimally. They don't mean say nothing. There actually was a case in Washington State a number of years ago where it was a gentleman who was born and raised in, was an Eastern African country. I can't remember which one for sure, but anyway, and immigrated to America and was involved in a critical incident in his apartment complex. And the country that he was from had a lot of corruption. And so in that country, you wouldn't talk to police or public officials at all. You could get you in a lot of trouble in a compromised situation. And so he didn't say anything. He called 911 and just left the line open. And then he wouldn't say anything when police came. And that ended up being, I wasn't involved in that case, but I have colleagues that were. And that ended up being particularly difficult for him. So anyway, so when attorneys say speak minimally, they mean speak minimally. The FLP attorneys years ago used to say what? There's been a shooting, or I had to protect myself, whatever it is, and then give the address. So they're not saying don't say anything. There's a gentleman by the name of James Duane, and I'm not advocating this guy's work or his book or anything, but years ago, I think it was about 14 years ago, he had a YouTube video that was on the Regent University School of Law YouTube channel, and it's got over 20 million views, and it's called Don't Talk to the Police. I'm sure many of you are familiar with it. And it's a 45-minute lecture, and it's him and then a police officer kind of go back and forth. Excuse me. And he also has this book. It's only been out since, I can't remember, 2016, I guess is when this book came out. But in the book, the title of the book is You Have the Right to Remain Innocent. And on page 41 of the book, he explains, and he's a law professor, and he practiced law for a number of years, apparently knows some of the Supreme Court justices quite well. So he says, nothing you tell police will be of any value to your lawyer at your trial, usually because of hearsay rules. And then on page 42, he says, what you tell police, with extremely rare exceptions, will never be revealed to the jury at your trial unless it is offered by the prosecutor and is used to help get you convicted. So, and there's a lot of other great explanations in this book as well. So anyway, take it for what you will. Again, I'm not advocating getting it or anything. Okay, so in my experience as expert witness, the folks that the clients that I'm working with, they've just had to use lethal force to protect themselves or someone they love in their home. Sometimes it's right outside their home. So they've just shot someone, and someone is going to jail. Oftentimes the person that's been shot is taken to the hospital or somewhere else if they don't make it. If someone's shot, someone's going to jail is kind of what seems to happen. There's nothing that I would be able to say to a police officer on scene that would get them to let me out of trouble. Often those police officers on scene, it's not their decision to make whether or not I'm taken to jail and booked. So it's going to happen. If we've used a firearm to protect ourselves or those we love, or some other tool, most likely it's going to be a firearm, and someone is gravely injured, someone is going to jail. And it's just that simple. So nothing I can say is going to allow me to talk myself out of it. So why try? Because that's just going to cause me more problems. Again, this doesn't mean don't say anything or don't call 911. That's not what we're talking about. But it does mean, I think, that I want to make sure I understand, and I want my learners to understand that there's a big gap between I'll talk to you after I talk to my counsel and this deafening silence that is there. That deafening, uncomfortable silence while you're sitting in the interrogation room. Um, and it's our humanness that compels us to want to explain our actions and defend ourselves. We want someone to understand. I mean, imagine you've just literally been in a fight for your life and you're scared and you want someone, you're second guessing yourself. It's just human nature to do those things. And so that long silence, that's what I think it's important that we decide what we're going to do during that and how we're going to handle that. And if we are going to say something, what are we going to say? Again, I'm not telling you what to say. These are just things we're talking about. So what do we say? Hopefully knowing about our humanness and that the logorrhea that can happen and that desire to defend ourselves and tell our side of the story, hopefully that's a good first step. And just being aware of that hopefully is a good first step to understanding what to do. When we come back next week, we're going to talk about some experts in this field, some law enforcement trainers and what they recommend, and some of the stuff that we learned during our Advanced Force Science Specialist course as well. And we'll kind of wrap this topic up. So we'll stop here for today. And this is the first part of, what did I call this again? The right versus the ability to remain silent. Thanks for being here, and we'll see you next week.